Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from the Law Offices of Prashanthi Reddy PLLC. Ms. Prashanthi needs no introduction, but if you need consultation, please log on to reddyesq.com for contact information. From the beginning, reddyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The reddyesq.com site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is the H1-B revocations and layoffs. We will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. Before we get into the topic, you can call us on the numbers displayed on the screen for questions related to immigration and also ask tips. Hi, Ms. Reddy, how are you?
Hi, Tony. I'm good, thanks. How are you?
Very well, thank you. So, Ms. Reddy, today we've chosen a very different topic again. Like the last time, you've chosen to talk about revocations and layoffs. So, would you want to start off with the questions, or would you want to start with what do you think about revocations and layoffs?
Right. So, the reason I chose this topic is because there's been a lot of layoffs in the news, right? So Metaverse or Facebook has laid off 13% of its staff, and I believe most of them are on H1-B. So I thought it would be apt, and I hear a lot of IT companies are laying off their employees as well, which I'm not surprised because it does happen towards the end of the year when they're trying to adjust their books. So keeping that in mind, I thought we will discuss about what happens when a non-immigrant gets laid off or their H1 or work status gets revoked, and what are the options available, and what are the alternatives, what should the person do, any benefits after they get laid off or they're not eligible for benefits. So I thought I'll just mention, we'll talk about that. So forever, both employers and employees always used to ask me questions such as, my H1B is getting over, or, I'm getting laid off. So what is the grace period? Is there any grace period? How many days before I fall out of status, or how many days do I have to, find another job? And before a few years ago, what I had to tell them that you don't have a single day grace period. Even one day that you're out of status, meaning one day that you're not on the payroll of the company, you're pretty much out of status. And it was very hard to tell them that, and it seemed almost like a inhumane law, because this put the employees really under the grip of the employers, and they were at the mercy of their employers really, because they could not, if they were laid off or their H1 was revoked, they would fall out of status immediately, and they had no recourse. But luckily for everyone, new regulations came up in January of 2017, which provided a 60-day grace period after employment is terminated. So this allows H1B and L1 workers to have a 60 days grace period. You get only one 60 days grace period within your H1 period. So say your H1 is for 3 years, within that 3-year H1 period, you get 60 days of grace. So you can't get 60 days of grace every employment cycle, right? Only within the 3 years you get 160 days, then the next 3 years you get another 60 days grace. So it's like that. So use it very carefully. So anyway, this 60-day grace period allows employees to then find other work and transfer their H1 or L1 to another H1 or to another L1 if they qualify. Or it allows them to file a change of status to another status. Or it allows them to just stay for 60 days and wrap up their plan so that they don't have to leave immediately. It's hard to leave immediately even if you don't have a job, because you'd have to close your bank account, take care of your businesses, take care of most probably your house or whatever lease or whatever you have. So a lot of affairs that you have to put into order, so you can't just get up and leave, right? There is also having to move, so all that. The logistics of it is just too complicated to allow you to leave, the next day. So, as I said, this 60 days grace period really helped employees not to be under the mercy of, their employers as much. It's still not a very long period of time, but, it's at least something, and something is better than nothing. So, basically, the 60 days grace period starts from the day that you are terminated or laid off. So you don't have to be laid off. You can choose to leave the job as well. So that's very important. In the early days when this law first came out, a lot of people would think that you only had to be laid off. But if you chose to leave, then the 60 days grace didn't apply. It applies in both situations. Whatever the situation might be, if you're not working, from the time that you stop working or you stop being on the payroll, you get a 60 days grace period. So this gives employees a some true control over their employment, because if they don't like the employer, if the employer is not paying them, if the employer is exploiting them, they can really then get up and leave and not be forced to remain with the same employer, right? So it's very important to know that it's not just being laid off or your H1 being revoked, but you can also choose to leave and you'll still get that same 60 days grace. So the other benefits, is there anything else we need to know once you get terminated? So the reason why employees are usually in trouble when they're laid off is that the employer has the obligation to withdraw the H1-B and notify USCIS. So, as per 8 CFR 214.2 H11, it is very important that the employer, that's how the USCIS made its regulations, H1-B regulations. So it's very important that the employer notify USCIS as soon as they terminate or lay off the employee. So this would then immediately lead to the employee being out of status because their H1 is then terminated. It's not like, things could be kept under wraps. So because of this, it made it hard for employees really to then keep their status. So important to remember, termination has to be done as per USCIS guidelines. An employer has a duty. If they don't terminate, then the problem is that they'll be liable then to pay. They might be held liable to pay the entire salary of the employee even after termination until the validity of the H1. So that's why, most employees, obviously they don't want to break the law and they don't want to be liable for, to make payments even after the employee is left. So that is an important reason why the 60 days grace period is significant. Also, another question that a lot of people ask me is, generally in the US, if you stop working, you're eligible for unemployment benefits because that is something that you're paying for. It's a benefit that you're paying for in your tax returns when you pay when your employer pays your taxes. But unfortunately, these unemployment benefits can't really be used by H1B workers because as per this unemployment benefit rule, the employee or the person should be willing and ready to take up any other job that becomes available to them. And unfortunately, they cannot take up any other job that's available because, it's a whole process. They have to file a H1 and it takes time for the H1 to get approved. Maybe the new job, they don't file H1. So that's why these unemployment benefits become a problem, in case of non-immigrant workers. Also, something to keep in mind when you're terminated is that you fall out of status, right? So you want to try and avoid falling out of status. Now, there are two types of issues that can occur. One is going into unlawful presence. Unlawful presence is something that happens if your I-94 is expired, or your H1-B has expired, or your H1-B has been terminated, and you continue to remain in the US for more than 6 months, then you are considered to be unlawfully present, and therefore if you leave, it only gets triggered when you leave. So if you leave, you cannot come back for a period of 5 years to a period of 10 years. A period of 3 years, 3-year to 10-year bar. So if it's 6 months to 1 year, it's a 3-year bar. If it's more than a year, then it's a 10-year bar. So that's unlawful presence rule. So you have to keep that in mind. Never stay after your I-94 has been terminated or your H1-B has been terminated, because you might accrue unlawful presence. And then if you leave and you try to come on a new H1, go to the consulate, they will not be able to issue you a visa. So that's one thing to remember, that's called unlawful presence. Now you might also not be maintaining your status even though you don't accrue unlawful presence. So for example, if you're on a H1 and you're not working for that employer, or you're not on the payroll of that employer, then what's happening is you're not maintaining your H1 status. Or if you're on an F1 and you're not going to school, then you're not maintaining your F1 status. So there is no bar for not maintaining status, but of course, anytime you fall out of status or you don't fall out of status, there can be serious consequences. There's no unlawful presence accrued, but still, if you leave the country and come back, most probably if you have been unlawfully present for a certain period of time, and if you don't have an appropriate reason for the period of time, say if you were out of status for a month and your I-94 expired or it was terminated and you couldn't leave immediately, so you took a month to leave. So that's fine, because you can always explain that at the consulate and say that, look, I had to put my affairs together, blah, 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 so therefore I had to leave. Now, of course, the 60 days grace period helps, because unlawful presence does not accrue anyway in that situation, and you're not out of status for that 60 days period. So that's how the 60 days grace period helps. And another thing that helps is when you are terminated, you can file a H1 within that 60 days grace period, and you can actually start working as soon as the H1 is filed. So I know how difficult it is to work, to stay in anywhere without being paid. So as soon as you file the H1, you can start getting paid by the new employer. So that's another thing, that the H1B portability law that can really help you when you're terminated. Another thing that can help, if you plan to return to your country, of origin, then the employer is responsible for return transportation for you, not for your entire family, but return transportation for you. So as long as you're leaving the country, they're supposed to pay return transportation. But if you choose to remain in the country and you're filing a change of status or a transfer to another H1, then they're not obligated to pay you that return transportation. This return transportation obligation of the employer is rarely, I think USCIS rarely really makes the employer pay, and so I have not seen USCIS ever impose any penalties for failure to pay return transportation. So it's not something that they enforce. Just something to keep in mind, but at least if you know what the rules are, you can demand that from your employer. And of course, it's not just filing a H1B transfer plus extension when you get fired. You can also file for a change of status to an F1 or a change of status as a stopgap to a B2 or a visitor's visa. So as long as USCIS receives that change of status application before that 60 days, you should be fine. So that's another thing to remember. You can do any of those things. But there are some exceptions. 60 days grace period is something that they're giving you. It's not a rule. They don't have to give it to you. It's a discretionary. So if for some reason, say you've committed some fraud while you are on a H1 and USCIS finds out about it, they may refuse to acknowledge the 60 days grace period. That's something to keep in mind as well. So that's, I think, what we have on layoffs. We can go to questions now if we have any.
Right. Right. So we do have a couple of questions regarding the same topic, Ms. Reddy, and we've gathered some of them. The first one is, how long can a person stay in the US after their visa is revoked or they're laid off?
So there's no law that says that you have to be, that there's a particular time that you can be out of status after your visa is revoked. But of course, I mean, other than the 60 days grace that we have, before that, there was no such law which said that, okay, you can stay in the country for a month or a day. Whenever you stay in the country beyond your period of employment, then you're pretty much, as I said, out of status for that period of time. Then you have to depend on the discretion of the consular officer, or if you're filing a change of status or transfer after that termination period, on the discretion of the officer who's looking at your H1 transfer application. Now with 60 days grace, of course, we have more better rules in place, and we don't have to completely depend on the discretion of the officer. The other thing to keep in mind is there is a 10 days grace period as well. I talked about the 60 days grace period, but I haven't talked about the 10 days grace period. So the 10 days grace period is basically when your H1-B, this is given to you after the completion of your H1 status. So say your H1, you've asked for a H1 for 3 years. So usually USCIS will give you a H1-B approval for 3 years and 10 days. Sometimes they put it in the H1-B itself. Sometimes they put it in the I-94 if you're traveling after the H1-B is approved for the first time. Then they'll put that grace period in the 10-day grace period in your I-94 in your I-94 card. So sometimes they don't, so you can just presume, if they haven't, that you have that 10 days before you have to leave to file a change of status, to file an extension, or whatever it is you want to file, or to just remain in the country for that extra 10 days. So 10 days grace period has always been there, that rule. But it's limited, it's not applicable to terminations or revocations. It's applicable for people who have exhausted their period on their I-94. So you have extra 10 days to remain in the country. So that's what that 10-day grace period is. So in addition to 60 days, you also have that 10 days grace period as well.
Right. Right. So moving on to the next question, Ms. Reddy, if a person has an H1-B status but also has employment authorization documents for their green card, should that person maintain their H1-B status?
So that's again completely up to the individual, of course. They don't have to. So say their H1-B was terminated. If their H1-B is terminated and they have an I-140 and a 485, an I-140 is approved and the 485 it's been at least 6 months since the 485 has been filed. We know again there's a portability rule for people who are in that situation, and we know that they can then move their green card to another employer as long as they are holding a similar job. So in this situation, if the person is on H1 but also has an I-140 approved and a 485 which has been filed more than 6 months ago, they can choose to then give up the H1. So they'll not even if the H1 is terminated or they've been laid off, they will not be out of status, because then they can choose to use their EAD and 485. But again, the EAD, the 485 has to always have an employer. So if the H1B employer and the 485 employer is the same, then they need to find new employment quickly and do the AC-21. There is no rule as to what the gap can be between the two green card employers, but I would say, be cautious and try to make sure there's no gap between the offer of employment from the first employer to the offer of employment of the second employer. Now say, another question I'm asking, I know you didn't ask, but I'm going to ask, something that I remembered. Say you're on a green card, or rather say that you filed for your labor certification or a perm, which is the first step of your green card, and you've been laid off, you're on a H1, fine, you'll file for a transfer, you have a 60 days grace period. What happens to your labor cert? Or what happens to your I-140 for that matter if you have not filed a 485? Then unfortunately for you, the perm will have to be refiled. But the I-140, if it's approved, you can use the priority date of that I-140. When you're filing your next perm and I-140, you can transfer that priority date to your second I-140. So that's one of the concessions that USCIS has given in case for people who have filed for their green card.
Right. So also, Ms. Reddy, can a person apply for a different status after being laid off?
Yes, so you can either, as I said, file for H1 transfer if you get a job, but or you can even, file for an L1, but there are, of course, certain restrictions for an L1. You should have worked for the petitioning employer abroad for at least 1 year before you can do that. So it's unlikely that you'll qualify for an L1. But you could qualify for, say, if your spouse is on an L1 or if your spouse is also on a H1, you could qualify for a dependent status. You could qualify for a H4 and then possibly apply for an EAD if your spouse has an I-140 approved and get an EAD and work that way. Or you can apply for an L2, which is if your spouse is on an L1. So that helps. And an L2, remember, is automatically employment authorized, so you don't even have to file for an employment authorization document. They can immediately start working. So it's really great to have these options, or you can just file for a change of status to an F1, as I said, or you could, but of course with the F1, the problem is that the schools have to start really whenever the F1 gets approved, and it's rather hard to predict when the F1 will get approved. And also because the processing time, it's taking so long for those F1s to get approved that, it may not be logistically possible to match the school start dates with, the approval of the F1. So that's something just from a logistics point of view to think about. But you could also file a change of status to a visitor's visa or a B2, just to help you, to give you some more time to then decide what you want to do, and maybe after that again file another change of status to a H1 if you get a job after that.
Right. And what about a situation where an H1-B, can it be revoked? Can a revoked H1-B be reinstated, Ms. Reddy?
That's very difficult. So if your employer terminates you, as I said, they're obligated to then withdraw the H1 with USCIS. And what they do is usually send a letter along with the copy of the approval and inform USCIS that you're no longer working there, your employment is terminated, and then USCIS goes ahead and revokes the H1 after the employer withdraws it. So once this is done, it cannot be reversed, unfortunately. So what will happen is then, if the employer decides to hire you back, they will have to again file for a H1 for you. H1. And if you're not subject to the cap, which most probably you won't be unless you're working for a cap exempt organization, you will be able to they'll be able to immediately file a H1 for you.
Right. And let's say a person has changed their status to H4, Ms. Reddy. Can they revert back to an H1-B?
Yes, they can. So say you have the 60 days grace, you didn't have enough time to find an employer, you don't want to leave the country, you can file for a change of status to a H4. And then once the H4 is approved and say you get a job then, and again, if you are not working for a cap exempt organization, that is if you are cap subject, then you can file for a H1 at any time. Also, it's good to note that the H4 could be pending at the time that you find a new employment, because the H4 processing is, again, everything is taking so long, over 6 months, 8 months, 10 months. So if that's happening and your H4 is still pending, you could even then revert back based on the pending H4. You could still file a change of status to a H1 and use the H4 as a bridge petition. that's possible as well.
Right.
At the most, USCIS can, say that you need to go out of the country because they're not willing to approve the change of status.
Right. And while we're on that topic, can a person look for another employer while their H1B petition is in the process of being revoked?
Yes. So depending on the timing of everything, after it is, so it really doesn't matter whether it's revoked or not. The moment that your employment is terminated, that's the time that your grace period is starting. So you can make use of that grace period. Say you don't have that grace period because you already used it once last year, and so this year again the same situation, you're encountering the same situation. Then what will happen is that before the H1 is, the fact is that you're not working, so you won't have pay stubs if you want to file for a transfer to another H1. So you'd have to again depend on the good graces of the officer, whether they'll approve the H1 transfer without pay stubs. So that's one possibility. But once the H1 is actually revoked, once USCIS takes that action and revokes the H1 and sends a notice saying that the H1 was revoked, then even that officer does not have the discretion to then approve a case after that, because you really have no status, and then you start also incurring unlawful presence as well.
Right. So with that, unfortunately, Ms. Reddy, we have to end the session for today's episode and continue the same in the next week's episode, because we do have some more questions left on the same topic, and we'd love for you to address them with all the information that you always give us. We're privileged to host you, Ms. Reddy. Thank you for being on our show.
Thank you, Tony. Take care.
You're watching Sakshi TV. This is Thorini. Thank you.